Well, first of all, let me say good morning to members of the media. As the invite said to you, this press conference is called to discuss labor relations matters. And I'll begin by saying to you that allow me to begin this press conference by referring to Senator the Honorable Michael Fay statement in the Bermuda Sun, January 4th, 2013, in which he is quoted as saying, he pledged to work with the unions to help ensure the economy moved in the right direction. The minister went on to say later in that article, I will be having open dialogue with the unions. The open dialogue that the minister promised in the article is not so open. Let me explain why. The BIU, along with our sister unions, one of our sister unions, represented on the Immigration Board in 2012. However, the minister has decided that the BIU will not be represented on the Immigration Board in 2013. Although our sister union will still have representation on that board, so you need to ask the question, is this personal against the BIU? On January 9, 2013, the Permanent Arbitration Tribunal members were gazetted in the Official Gazette. You may ask what is concerning about that. The BIU firmly believes that the minister, Mr. Fay, in making that appointment, is in violation of the Labor Relations Act 1975. The Labor Relations Act 1975 under Section 14.2 states that the chairman and deputy chairman of the Permanent Arbitration Tribunal shall hold office for a period of 3 years and be reappointed from time to time for a like period. And Section 14.5 reads, the members of the panel shall hold office for a period of 2 years and may be reappointed from time to time for a like period. It is my understanding that there are members of the Permanent Arbitration Tribunal who have not served out their term, and the minister has removed them without consultation with them. But what is most concerning about the appointment of the Permanent Arbitration Tribunal is under Section 14.2, which reads, before exercising his powers under Section 1, the minister shall consult with such trade unions and other organizations as it appears to him to be representative of the views of the employers and the workmen in Bermuda. I can tell you the BIU was not consulted, and I have spoken to one of our sister unions who has assured me they were not consulted either. So where is the open dialogue with the unions that the minister promised would take place? Once again, the BIU family believes the minister is in violation of Labor Relations Act 1975. I do have a prepared statement that Ms. Furbert will hand out to each one of you once the press conference is concluded. Any questions?
Have you approached the minister with regard to these omissions?
No, I have not.
Boards and so on?
No, I have not.
Do you intend to?
I do.
Could it be that this might be headed to the courts based on you saying that these actions run all through the various pieces of policy that you mentioned? Well,
Mr. Marino, I would like to say to the country, the BIU is on record from time to time saying that it would appear that there's any laws in this country for trade unions. There's no laws for employers. Now you have to wonder whether there's any laws for the ministers of the country, right? Because this clearly states that there's a statute on the books that the minister should be followed in making certain appointments to boards or whatever, and it's clearly that the minister, my understanding, is a lawyer, right? The AG, not, I guess, pointing fingers right now, but is also a lawyer. How do you go and make these appointments without the consultation process in relation to what the Labor Relations Act 1975 says, Section 14.2?
Have you spoken to other unions? Have they been consulted?
Well, I can tell you that that's an interesting question because, as I said, I spoke to one of our sister unions who said they had not been contacted either. I spoke to Brother Mike Charles this morning from the Bermuda Trade Union Congress, who is, of course, the General Secretary of the Bermuda Union of Teachers. But he did say that he got an email on January 8th at about 10:13 in the morning about the appointment of the Permanent Arbitration Tribunal. The mere fact that this was the day before it was gazetted in the World Gazette, how much consultation was going to take place on the 8th, between the 8th and the day that was gazetted? So you need to ask yourself the question, open dialogue? That's not what we call open dialogue. Open dialogue means that I have intentions of appointing these members to the board. We need to sit down and have a discussion. Whether it takes a couple of weeks or a week or so, it certainly needs to take more than about 6 hours, because I think the deadline that Brother Mike said to me, they had till 5 o'clock that afternoon to respond to that request that they got at 10:13 on the 8th. I'm not sure what time it was sent to the Gazette for them to print it, but you got to know that my understanding is that you probably, call the World Gazette or whichever newspaper you're going to be advertising, saying I have an article that I'd like to publish. Please hold a space for me or whatever have you. So maybe that's Mr.
You said that one of your sister unions is still represented on the board.
Yeah. I'm not going to tell you which one it is. I can't do that.
Have you seen the board lineup?
The immigration board?
Yes.
My understanding is that they should be posted later on this month. So rather, I believe they said.
What about the members of the arbitration panel?
Yes.
You know who they are?
Yes.
You're not pleased with who they are?
Well, let's just be clear. That's another interesting question, because you would know that there are at least 2 members of the board, and I would say one in particular, because whilst we know that Nicholas Kemp ran as a candidate for the ABA, Mr. Thad Hollis happens to be the chairman of the ABA. How do you appoint Mr. Thad Hollis to be a member of the Permanent Arbitration Tribunal that's going to sit, in her cases, as a chairman of the ruling party?
The OBA could say that he's a negotiator by trade. I'm just being the devil's advocate, and are you accusing them of stacking the deck? Would you spell it out?
I'm not accusing them of anything. What I'm saying to you is that it's quite obvious that Mr. Hollis could potentially have a conflict of interest, because you have on the one hand where the minister is referring a matter to the Permanent Arbitration Tribunal for settlement, and you have the chairman of the party sitting there, or could be potentially sitting on one of them panels.
So it would appear that they're stacking the deck.
I'm not. That's not my terminology.
Okay.
That's not my terminology. My terminology is he would have a conflict of interest.
Okay, thank you.
Why is it significant that the unions have representation on the immigration board?
Well, I think, Mr. Marino, when you look at it from the point of view that, you're talking about work permits, you're talking about, jobs, you're talking about the protection of jobs for Bermudians and those sort of things, and for labor to be there and have an eye on what's taking place as far as approving work permits and those sort of things, helps to bring some checks and balances in place in the immigration board process. So the mere fact that he's decided to remove the BIU from that board, my predecessor, Mr. Bridges, was on the board for several years before he was replaced, and maybe either in 2003 or 2004 he was taken off. He left the BIU in 2006. I was appointed by Minister Miners last year to serve on the immigration board for 2012, because I think they saw the need that it's time for labor to be on the immigration board table, because there should be a balance between whether it's civil servants or whoever they are and employers around the immigration board table, to make sure that the balance is there when you're making decisions to approve or not approve a work permit.
The government could argue that it's simply a case of sour grapes on your part.
Well, Mr. Marino, I like to think that the BIU approaches a position approaches anything from a position of fact, right? It's a position of fact. And let's set aside the thing about the BIU not being reappointed to the immigration board. I'm not speaking about the permanent arbitration process, right? The appointment of the Permanent Arbitration Tribunal, where dialogue should have taken place, and it's clear. It doesn't say that, use some kind of word. It says he shall consult. So it's not may, where he can, maybe have a question. It says he shall consult with those unions and the employers and whatever before he makes that appointment. And it's quite obvious in this case that he did not do it. So it's not a matter of sour grapes. It's about making sure that, whatever government is today, they follow what the laws of the land say. People are going to try to say that the dock workers division of the BIU, the poor workers division of the BIU, we're in violation of it because they darn tools. They broke the law. Well, we can't have, a set of laws just for the employees or the workers. We've got to have a set of laws for everybody, and whether that's the government or whether that's the employers also, we've got to make sure that everybody follows the laws of the land. Nobody's exempt from that.
Have the concerns that you highlighted been raised with the Trade Union Congress? So what was the outcome?
Well, I can say to you that whilst I have spoken briefly to, one of our sister unions, and I've spoken briefly to Brother Mike Charles, these are some of the things that we intend to address. I think our next meeting is scheduled for 4 o'clock next week, Tuesday, at the BPSU.
Are you concerned that in light of the panel makeup,
Yeah.
the docks dispute won't get a fair ruling?
Well, I can't speak to that. And the reason why I can't speak to that, I would like to think that the people that are appointed to basically, be the chairman, the deputy, or the other two members of the panel, because there's three tribunal members, right? That they are, they will carry out their responsibility with integrity and the whole 9 yards. The mere fact that two parties have agreed to go to the arbitration process, neither party can say they don't like the outcome, because the award is binding on both parties. Now, if the tribunal errs in law, if they err in law, then it leaves either side the right to go ahead and appeal via the courts to do A, B, C, or D. I can tell you that there is a terms of reference that's being drawn up that's causing us some grave concern right now. I can't speak to the terms of reference right now because we're sending it to our lawyers to get a legal opinion about the terms of reference, because it looks like the terms of reference could be not the jurisdiction of the tribunal, because I think it's a matter for the courts to deal with, particularly when the matters are in there that they're asking for the tribunal to give consideration to.
So in the first few days of a 40-day cool-off period, things are not that cool.
Well, let's just be clear. The 40-day cooling off period is for the dock situation, right? And I don't want people to think, well, it's the dock situation that's creating this.
Permanent arbitration panel.
It's the appointment of the permanent arbitration tribunal that's going to hear this matter within the next 40 days.
So these are not that cool then, the first few days.
Well, I guess if you want to look at it in that light, I guess you can come to that conclusion.
Mr. Furbert,
Yes.
given that you haven't spoken to Mr. Fick, and given that he's a lawyer, and Mr. Pattingill is the Attorney General is a lawyer,
Yeah.
would it be a stretch to suggest that this might be just another inexperienced
Well, Mr. Webb, whilst I can understand your question, I think the difficulty I have with that is that you have civil servants that were under the PLP that are still there now with the OBA. So as far as giving direction to incoming ministers, all they would need to do is ask the technical staff, what's the normal procedure when it comes to doing A, B, C, or D? And hopefully, if they didn't get pointed in the right direction, well, maybe that's where you might want to lay the blame. But I can't say that inexperience, that Mr. Fay or Mr. Pattingill was inexperienced, and they didn't know that the appointment of 14-2 is sitting right there in front of them. I'm sorry, but I don't believe that. It is a stretch. It's a stretch.
Plan to take this up with the minister at your first meeting next week?
I think we plan to send the minister something in writing to that effect, and hopefully the meeting that we have him next week on the 16th of January at 2 o'clock will be discussed.